It's now my pleasure and my honor to introduce our closing keynote today. We've gone out of our way during this session not to give long intros of people. Everybody has the program, and everybody's bio is in the program. I'd encourage everyone to read Attorney General Schneiderman's biography in the program. It's great, and starting with talking about how Attorney General Schneiderman fights on behalf of ordinary New Yorkers and all New Yorkers, and to protect them. To me, the one burning question is how somebody as intelligent, successful, and charismatic as Attorney General Schneiderman could have gone to a safety school like Amherst College. Sorry, a little bit of Williams-Amherst humor there, rivalry. Anyway, without further ado, Attorney General Schneiderman.
Thank you. Thank you, Scott. Thank you, I think. Great to be here. I love talking to groups of lawyers. The Williams-Amherst rivalry is at a level of intensity such that I remember us losing a football game badly when I was there, and our side started chanting, higher mean SATs, higher mean SATs. So, but I always like talking to groups of lawyers, and I have an unusual background, unfortunately, for statewide officials in the United States, in that when I got out of law school, I clerked and then spent 15 years in private practice as an associate and then a partner in a big law firm. And that framed a lot of my views and gave me tremendously valuable experience before I went into my second career in politics, which is happens to people. A lot of people don't realize that Mahatma Gandhi's first career was as a lawyer, and if he perhaps had been a more successful lawyer, he might not have gone for a second career and becoming a saint. But it's I'm very proud of the tradition of American law. I love speaking at law school graduations. I am pleased to be here in front of such a wide array of legal talent. But I now am running a big law firm myself, and I like to think of it as the best public law firm in the country. That's certainly our objective. I don't believe that the people of the state of New York are entitled to any less representation than my corporate clients used to get back in the old days. And I want to make some remarks about what I think is an actual problem that is emerging in the law that we, as lawyers, should be all aware of and all addressing. It is my job to make sure that I protect all of the constitutional rights of New Yorkers, but it's also my job to protect New Yorkers and New York businesses from fraud, corruption, and other illegal conduct. And today I want to talk with you about what I consider to be a dangerous new threat to the fair and effective functioning of our laws and of our markets. It's a threat that seeks to transform First Amendment rights into a weapon that can dismantle essential law enforcement tools that prevent fraud and protect public safety. So this threat, which I and some others call First Amendment opportunism, rests on a false premise, that free speech rights of corporations can supersede the duties of our democratically elected government officials to protect the people we represent. And this arose recently, and many of you know, and are some of my friends from Paul Weiss here? No? Oh, well, they're all too bad, because I'm going to talk about their client. Actually, they're probably back home billing. My office is currently investigating whether fossil fuel companies, particularly ExxonMobil, deceive their investors, regulators, and consumers about the risks of government action to address climate change and how those risks are affecting their business and the value of their assets. Peabody Coal, which was at the time the largest publicly traded coal company in the world, has already agreed to settle a similar case. Our investigation into Peabody revealed that they had been deceiving their investors about how efforts by governments around the world and of private companies to cut back on the use of coal would affect the market for its products. For instance, we found that they had been submitting filings to the SEC for years, claiming that they couldn't predict the impact on their business of specific laws or regulations seeking to limit the use of greenhouse gas and limit greenhouse gas emissions. The company said that it was, quote, not possible to predict the impact of such laws. We then discovered that they had done the exact analysis they claimed was not possible to do. In fact, they paid a lot of money to a major consulting firm to figure out precisely how a variety of proposed government actions would affect the market for coal. And they made a variety of other serious misrepresentations, including misstatements about the findings of the International Energy Agency And I hope that we can all agree that that sort of conduct is fraud. The lawyers for Peabody essentially did agree, and as a part of our settlement agreement that ended our investigation, they went back and revised all their shareholder disclosures, SEC filings, and have committed to cleaning up their representations on issues relating to climate change and the valuation of their coal assets in the future. Around the same time that we settled the Peabody case, we launched a similar investigation into whether or not ExxonMobil had misled investors, regulators, and the public about the risks of climate change and how those risks would affect its business and the value of ExxonMobil's assets. For example, Exxon has repeatedly and publicly claimed that they could not predict the impact of climate change. Their CEO testified before Congress in 2010, no competent model existed to predict what was going to happen with the changing climate. At the same time, all the evidence suggests that they were making their own strategic business decisions at that very time about where to drill in the Arctic based on their scientific and engineering studies that projected rapidly receding ice sheets, melting permafrost as a result of climate change. As everyone knows, at the United Nations Climate Summit in Paris last December, virtually every nation on Earth promised to all but eliminate the use of fossil fuels after 2050. And many governments have taken action since then, including our own. The governments have pledged to abandon oil, gas, and coal in favor of renewable energy. And if you look at new electricity being added to the grid globally, virtually all of it is electricity generated by renewables. They're not building coal plants anymore, and they're not really building oil-burning plants anymore. So our contention is that Exxon's investors have a right to know how these changes will affect the company's business model, the value of its assets. Same is true of other businesses and of consumers. So we're essentially asking the same questions we asked of Peabody Coal. But unlike Peabody, it's clear that there is a very well-funded network of allies of ExxonMobil that don't want the company to have to answer these questions. So rather than simply accepting that my office, which has now been joined by several other attorneys general, are conducting a legitimate investigation, a group of climate change deniers and organizations that they fund have launched what I think is a very cynical and in fact dangerous attempt to cloak alleged corporate malfeasance with the First Amendment, claiming that anyone who challenges their right to peddle false and misleading information is attacking the sacred American tradition of free speech. Now, to me, this is nonsense. But this is an effort to undermine law enforcement with spurious First Amendment claims, and that's what I call First Amendment opportunism. This is a phenomenon that has been growing rapidly over the last decade. A group of conservative groups, climate change deniers and their attorneys, took out a full-page ad in the New York Times a few weeks ago, blasting my un-American fraud investigation, which they said would, quote, silence the views and voices of those who disagree with me. I then received a letter from the chair of the Committee on Science, Space, and Technology of the United States House of Representatives asserting that we are conducting, and again, this is his language, a coordinated attempt to attack the First Amendment rights of American citizens. So I can assure you nothing could be further from the truth. We're conducting a serious investigation into potential securities fraud, business fraud, and consumer fraud. That's all it is. No more, no less. It's the same set of questions that we asked Peabody, and it's a very important, to me, line of inquiry. So let me just get out there my core principle in opposing First Amendment opportunism, and I hope that you as lawyers, and given our duty to uphold the law and to actually improve the law under the canons of ethics, will join me in believing that the First Amendment does not give you the right to commit fraud. You do not have First Amendment rights to run a three-card Monte game. Not protected, not protected. Seems pretty obvious to me and other law enforcement officers, but I have been shocked at how many people are willing to argue the opposite. Fair and reasonable limits on the First Amendment have always been accepted. They're critical to maintaining free speech while protecting citizens from fraud and other misconduct. And in one of the first cases testing the then just emerging First Amendment opportunism that I'm talking about, Chief Justice William Rehnquist wrote, and this is not a justice I quote a lot, but Chief Justice William Rehnquist wrote, quote, "The liberties of political expression are not at all necessary to effectuate the purposes for which states permit commercial corporations to exist." And Chief Justice Rehnquist, I think, would probably be shocked by the growth of the wave of First Amendment opportunists who are seeking to drastically expand the protection of false and misleading corporate speech, and who I believe pose a threat to honest investors, consumers, and competitors, and in fact to our markets. The Federal Food and Drug Administration and the Federal Trade Commission have been assaulted with these arguments over and over during the last decade. A company that produces the pomegranate juice called Palm Wonderful, for instance, claimed the juice reduced the chance of heart disease, prostate cancer, and even erectile dysfunction. None of these things had been proven. There was no scientific basis for it, but that didn't stop them from claiming they had a First Amendment right to make these unsubstantiated claims. Same thing with the makers of some green tea products, who said it was their First Amendment right to promise lower odds of breast and prostate cancer, despite a complete lack of scientific evidence backing up the claim. Earlier this year, my office got more than 24 tanning salons across the state to stop claiming, and this is actually what they were claiming, that tanning beds prevented and even cured cancer. The tragic truth is they do just the opposite. And I suppose at some point I may be hearing this sort of an argument in my consumer fraud case against the most famous phony university in America, the so-called Trump University, which was never a university and which we allege was really just a scam to defraud more than 5,000 consumers out of millions of dollars. The First Amendment does not protect fraud. It doesn't protect fraudulent speech. And I'm sorry to report that the rising wave of First Amendment opportunism is now stretching far beyond consumer fraud. In 2010, a hedge fund called Full Value Advisors tried to use the First Amendment to shred a rule requiring the disclosure of stock positions in excess of $100 million. The company argued that simple public disclosure of its investment would drive up the price of stocks they were targeting, making it harder for them to acquire the stocks they wanted. The regulation had been on the books for 32 years, but that did not stop Full Value from pushing their case based on this First Amendment theory. Thankfully, the D.C. Circuit dismissed that case on ripeness grounds. But then, in an even more bold move, in 2012, the American Petroleum Institute and the U.S. Chamber of Commerce attempted to use First Amendment opportunism to block an anti-bribery measure that was passed as a part of the Dodd-Frank Act. Now, this measure was simply a law that required corporations to disclose any payments they made to foreign governments. Bill Gates, at the time, said this part of the law was critical because, again, I'm quoting, "It is in the most secretive jurisdictions that corruption, poverty, and instability flourish, and the risk to investors is greatest." But the opportunistic radicals at the American Petroleum Institute and the Chamber insisted that the law compelled U.S. companies to, quote, "engage in speech that they do not wish to make." These arguments are being made increasingly and with increasing force, and I think as lawyers it's up to us to answer them and to respond to them. You could use the same argument, by the way, that they're making about the anti-bribery provisions to neuter any sort of disclosure form. I suppose the simple act of filing tax returns could be construed as coerced speech if you follow this line of argument. So I want to challenge you today, if those of you who aren't familiar with this trend, because I am tremendously proud of the tradition of American lawyers. I love speaking at law school graduations. For those of you who have been fortunate enough to get tickets to see Hamilton, you know, it's very inspiring to look at the great work of the lawyers who are our founders and the tradition that inspires us and should animate all of our legal work today. And I think we all need to call out the fact that the campaign of First Amendment opportunists has the potential to undermine a lot of very important laws set up to protect against different types of fraud, consumer fraud, securities fraud, business fraud. And it has the potential to impede American law enforcement agencies and prevent legitimate efforts to protect public safety. So to close my talk this afternoon, I just want to remind you of what life was like before we had the anti-fraud regulations, which we now have been taking a bit for granted, in my view. At the beginning of the 20th century, non-prescription medicines, or so-called patent medicines, were tremendously popular. Slick salesmen claimed that these medicines could cure pretty much anything. People were buying them like candy, but no consumer had any idea what was in them. Then Colliers magazine launched an investigation in 1904 and found that gullible Americans would spend $75 million on patent medicines that year alone, which is nearly $2 billion in today's dollars. Of course, without any truth in advertising laws, no one could be sure what they were buying, so the Colliers investigation uncovered a lot of shocking facts when they did examine what was in various bottles of medicine that they purchased. They found cough medicine laced with cocaine and opium, children's tonics that were essentially bottles of alcohol, headache powders that sometimes created heart disease and in one case actually stopped someone's heart. And their expose and similar investigations that were launched at the time, one of them leading to Upton Sinclair's seminal book, The Jungle, the following year, changed America's understanding of the need for consumer protection laws. And it was public outrage at this wave of fraud that finally got our first major consumer safety law, the Pure Food and Drug Act, passed in 1906. And that act ushered in more than 100 years of vital government regulation, a century of progress that the First Amendment opportunists are threatening to dismantle. Now, I am the first to acknowledge that we often overregulate or poorly regulate in the government. But this attack does not distinguish between reasonable and unreasonable regulations. This is an attack that could threaten to undermine any sort of regulation that protects consumers, protects investors, and protects our markets. Fair and accurate disclosures are cornerstones of every area of law, not just securities law, which I spent a lot of time doing when I was back in private practice, and happy to continue doing it today. Consumer protection laws, and also very important laws to protect public safety and national security. So to me, First Amendment opportunism threatens to undercut my office and all of us in law enforcement, and also to undermine the essential American principle of equal justice under law. It creates a problem for every competitor that follows the law, makes the proper disclosures, and doesn't lie to consumers, to investors, and to regulators. So I would urge you to join me and all right-thinking lawyers, business leaders, and government officials in rejecting these destructive efforts to morph the First Amendment into a warped shield against clear violations of the law. I know that the vast majority of businesses play by the rules. I know my fellow members of the bar help them to do so. That's our job. And so as lawyers, I think you're in a vital position to rise to this challenge. We've got to keep our markets fair and free. We should be talking all the time about better regulations and doing a better job. That's perfectly legitimate debate. But you are on the front lines of what I think is an increasingly dangerous struggle. And I respectfully submit that it's time for responsible lawyers to raise their voices and reject First Amendment opportunists for what they are. I will be honored to work alongside you in our collective effort to protect the public and to ensure that our markets are fair for everyone. But this is a real challenge. And as I said before, our duty as lawyers is to represent our clients, but under the canons of ethics, we are also have a commitment to protect and actually to improve the law. I think we need to protect our law. I think we need to protect our regulations, and I think we need to protect the people of the United States from this very dangerous legal trend. So I invite you all to read up on it, and I hope that some of you will join me in calling this out for what it is. It's a bad trend in law, and the only people who can deal with it are us lawyers. Thank you very much.